Good morning. Please be seated. Oops, sorry there.
Nope.
This is the time and date set for oral argument in cause number CV 19-0029, Benjamin Aguilera versus Joel Sains. These proceedings are being audio and video recorded as well as live streamed, so we ask counsel to please identify yourself and your client at the beginning of your argument. Each side will have 20 minutes. Appellant's counsel is responsible for watching the clock to reserve a portion of that time for rebuttal should you choose. We've read the briefs. We have conferenced this case. We are familiar with the facts. Please consider that in your presentation. At this point, counsel, are you ready?
Yes, sir.
Please proceed.
Dennis Wolinchek and Chris Myers for Benjamin Aguilera. I'd like to start off, if I may, with a reference to the committee note of Rule 702, which I think is pertinent. And in pertinent part, it says, the amendment is not intended to supplant traditional jury determinations of credibility and the weight to be afforded otherwise admissible testimony, nor is the amendment intended to permit a challenge to the testimony of every expert, preclude the testimony of experience-based experts, or prohibit testimony based on competing methodologies from the field of expertise. The trial court's gatekeeping function is not intended to replace the adversary system. Cross-examination, presentation of contrary evidence, careful instruction on the burden of proof are the traditional and appropriate means of attacking shaky but admissible evidence. And the reason why I start with that is because I think it starts and finishes really most of the discussion for me. The court here interposed itself, and without any notice, without a Daubert hearing, without anything, without even an argument from opposing counsel, found sua sponte in the minute entry order that Mr. Porter's affidavit was simply to be tossed, to be blunt, and that Mr. Aguilera's declaration was to be ignored. We're dealing here with what's more probably true than not. And in my opinion, the court had no right to sua sponte without any prior notice or any prior hearing or anything else to essentially toss our evidence when, in fact, per the hydroculture case and through Orm School, there had never been a statement or a position taken by the opponent other than just generically that we had not produce witnesses or evidence on causation, which was not correct since we had disclosed expert testimony.
At least in the abstract, Mr. Wolinchek,
yeah.
The court has a role or responsibility as it relates to the foundation for an opinion, admissible opinion, correct?
I'd say it's generally correct.
So a preliminary question of whether there's foundation or not. And so if the court considered but rejected the proffered opinion on the basis of a lack of foundation, you think that was error?
Yeah, I do. It's clear error. First of all, we're not talking about a trial scenario. We're talking about a response to a summary judgment which simply raised the issue of causation without any expert testimony, without anything, and without complying with the Orm School standard of specifically referencing what it was that they're referring to that we didn't provide, because frankly, I'm not sure we needed any expert testimony to go to a jury on this particular matter, because it's clear that it's more probably true than not, without any expert testimony to begin with, that a law firm such as Greenberg Traurig, with a shareholder at the time, Mr. Aguilera, would never have not tendered to its carrier or defended. They would never hire another lawyer had they done that. So to answer your question,
well, in looking at the underlying complaint and amended complaint, I didn't see any allegations in there that Greenberg was named or liable, or that the acts complained of by Mr. Aguilera were performed in the course and scope of his relationship with that law firm. So I'm struggling to understand why Greenberg would have paid much attention to this, let alone Lloyd's would have paid any attention to it.
Well, that's interesting, Your Honor. I disagree. I think it's clear that he was a shareholder at the time, that he was acting on behalf of the firm, that the firm...
How was he acting on behalf?
He was a shareholder of the firm.
Just because you're a shareholder, when we're talking about the scope and course of what this litigation is about, we're talking about intentional conduct partaken by your client. So how is he, by nature of being a shareholder, covered under the Lloyd's policy for intentional torts?
Well, again, I don't know that he's covered under any policy. The issue is whether or not he would have been defended under any policy or under policies of Greenberg or the insurer. The fact that there was intentional conduct alleged would not have barred that based on his own affidavit or declaration, I think, based on his own declaration where he stated that in the Yankee case, which was also involved in the same set of facts, that in that case he had personal knowledge that Greenberg did tender and was defended in a case involving the same kind of claim of intentional conduct. In fact, it wasn't intentional conduct. It was found not to be fraudulent or intentional. And
Wasn't
therefore...
Greenberg a party to that other case?
I'm sorry?
Greenberg a named party in that other case?
Yes, but the problem in this case is Aguilera was deprived of his right to sue Greenberg-Trarg on the basis that they should have defended the claim, regardless of whether they would have covered it. It's obviously two separate issues. Would have defended the claim as they have all other such claims, as his declaration was saying, in a similar scenario where they did so. The fact that they were defending that claim is irrelevant because that's the whole point here. Aguilera was deprived of his ability to bring any claim against Greenberg-Trarg for indemnity on the basis that he was acting as a shareholder pursuant to his duties there, and he was.
So I'm sorry to interrupt,
Yeah.
Mr. Wolnichek. So your indemnity theory is not sort of classic indemnity claim where a principal is held liable for the wrongful acts of their agent performed in the course and scope of that employment relationship, so that the employer has a claim of indemnity against the employee. Your claim is actually the opposite.
That's not correct, Your Honor. There's no rule of law that says that it goes one way and not the other way. Of course, an employee has the right as an agent to seek indemnity from the employer.
As I understand the law in that area, it requires that employee not to have engaged in the wrongful conduct.
The answer to your question is really simple. That's an ultimate determination that's going to be made at the end of the litigation with respect to that issue. I don't know where that comes out, although I do, because this matter was heard by the State Bar and it was dismissed on the basis that there was any intentional wrongful conduct. But that's not a determination that's made up front to defend a case. As I think you know, it happens every day of the week that insurance companies as well as law firms defend cases under a reservation of rights and then determine whether or not, in fact, the conduct is wrongful. They don't make that determination up front and say we're not defending it if, in fact, there's a contrary position, which there is. He didn't admit that there's any wrongful conduct or intentional conduct, and it deprived him of the ability to go after the firm or to know exactly what would have happened had it been tendered. Now, look, let's talk reality. I mean, you're sued. You don't tender it to your employer and give them an opportunity to defend. In other scenarios, you know that they probably would, or any large law firm is going to defend their employee or their shareholder, regardless of whether they cover them or not, and determine where they go from there. But they didn't do that here, and they deprived him of the ability to then, because if there's no notice, you can't sue for indemnity. That's obvious. So there was no notice given and no ability. And the problem here is we'll never fully know, in truth, what would have happened, but that's not a result of anything Mr. Aguilera did. That's because of the actions of Mr. Sanis.
So
You can't argue that this is speculative. I'm sorry, I didn't mean to.
Oh, yeah, too many intrusive thoughts. I apologize. When you start talking about notice, so that your client was served with the amended complaint in 2007. And the first reference I see to some discussion about a tender, regardless of who initiated it, whether it was Mr. Aguilera or Mr. Sanders, is in 2010, and then raised again in 2012. And the allegation, as I understand it, is that Mr. Sanders was negligent in not tendering the defense in 2012. And so,
Well, it should have been tendered immediately, regardless.
well, your client's a lawyer. He could have done it, and he was invited to do it by Mr. Sanders, the way I understand it.
Okay. Actually, all those are factual determinations, but putting that aside, Mr. Aguilera is an international business lawyer, okay? He is not a litigator. We made that clear. He does not know anything about tendering or any of that kind of stuff, as it might appear to you. This was his litigation lawyer. Any litigation lawyer would know to do that. I don't think that's a rocket science. And it wasn't done, and therefore we're deprived of knowing exactly what would have happened. The problem here is it's fraught with speculation, I concur, because of what Mr. Sanders didn't do. Now, if we went, according to the judge, and went to Greenberg-Traurig, which they could have done too, and asked, what would you have done, we get the same answer that we're going to give you today, which is nobody really knows. You know, it was 10 years ago, there was lots of things under the bridge, people like leaving, et cetera, and no one's going to give you a straight answer from an insurance company or the law firm that, yes, we definitely would have defended this. The answer would be that we would look at it and we would determine, right? The problem is that you get no further assurance from that looking back in time than you would if you get Mr. Porter's affidavit. There's not going to be much of a difference. Mr. Porter's going to give his opinion based on his experience, no different than somebody at Greenberg-Traurig today looking back and saying what they think. And had that happened, had they said we probably would have defended it, whether we would have covered it, who knows? But we probably would have defended it until we got that determination of whether it was wrongful conduct and a defense that we would have. I guarantee you the other side would come back and say, well, that's insufficient because you don't have any certainty as to what would have happened. So, you know, any lack of certainty is not caused by my client. It's caused by a litigation attorney who knows, and I think you know this, that when you're dealing with something like this, you tender it immediately. And, you know, now we're being told, well, you don't know what would have happened. Well, it's more probable than not, according to Mr. Porter, what would have happened based on his 50 years of experience, and that is that the firm like Greenberg-Traurig would have definitely defended it. And based on what happened in the Yankee case, notwithstanding that they were at party, I don't think that's all that distinguishable, because in all the cases that Mr. Porter looked at, where, you know, there were others as well as the firm, I believe his affidavit says they're all represented by the same person. And so therefore it leads to at least a reasonable inference for a jury to find more probably than not that the firm would have taken control of the litigation and at least defended it. And of course, we know it wouldn't have concluded ultimately that there was wrongful conduct because there wasn't any. So there was no fraud found or anything like that. And in fact, without getting too deep into it with the time I've got, it was basically a situation where it was misunderstanding because Mr. Aguilera had to form a separate company in order, under Mexican doctrine and principles, to proceed with what he was doing, and that was construed to be some kind of a fraud.
So, in the interest of time,
yeah.
I'd like to get your input on what I think is an argument the other side raises having to do with the retention, and that under the policy that Greenberg was a named defendant or was involved in the conduct, or its shareholder, that either Greenberg or the shareholder would be responsible to pay that retention before Lloyd's obligation under the policy kicks in. I'm intuiting from some of the deposition questions, etc., that the other side contends that Mr. Aguilera would have been responsible for the first $7.5 million of defense and underlying settlement or verdict before there was any obligation.
Well, again, I think the key word there is intuitive or whatever. These are all things, the terms are undefined. We do have the Yankee situation, as I said, which was
different
similar.
situation, Mr. Womajack.
I'm sorry?
Different allegations.
Very similar allegations.
Well, I
And
don't think-
Yankee was involved in the same deal.
Well, if I'm remembering those allegations, they involved alleged negligence and respondeat superior with Greenberg being named as a defendant.
Well, I as I said, Greenberg was named as a defendant, but the claim was defended even under that same retention language that Greenberg has, and it was less than a $7.5 million claim, and we know that it was defended. So Greenberg apparently defended it.
Well, who paid for that defense?
Well, I don't know. That's the problem. I agree. I don't know. But I do know that it was either Greenberg or it was the insurance company. And so that's the problem we've got going back in time. But the reality is we do know that it's less than $7.5 million. We do know that they were defended, and that it was tendered to Lloyd's. And as far as I know, it was defended by them, according to the little we do know. So I don't know that retention language was ever interpreted. And I have to say, whether you agree with me or not, that the other point that Mr. Aguilera brought out was the fact that he has a Lloyd's policy following his leaving Greenberg. He's back there now. But and that had specific deductible language and terminology used that was in that policy. So I don't know exactly what retention means. I think there's a lot of debate on what it means. I understand their argument, but there's also separate language in there talking about claims expenses and so forth being deducted from, and I don't know what that means, to be very honest, and nobody did below. It means that we should have basically proceeded on and had a fact-finding determination, but all we had from the other side was just challenging that you don't have causation, and that was about the extent of it, and then the judge throwing out our affidavits. And so we're left with no cause of action over somebody not tendering to a large law firm and an insurance company that dealt with them, and no recourse. And they're saying, well, you can't prove now conclusively that what the law firm would have done. And I'm saying, I'll repeat again, that's not because of us, it's because of you. You created that situation where we don't know exactly, and then you want to profit by it, basically. That's the problem I've got with that. And so all we can say is, would a jury be assisted by Mr. Porter's testimony? That would be more probable than not, under the circumstances, that a law firm would not just say to a shareholder, we're just going to send you on your merry way and you're going to pay for this yourself, without first defending it. And we believe that most large law firms would not do that without a fact-finding investigation. Had they done that, they would have found that there was no fraud or wrongdoing.
So, just so I understand, your position is that on this record, there was a factual basis for Mr. Porter's opinion.
Yeah, and under the basis of the law, there's no requirement that the judge put in there without any notice to us, which we could have corrected even had he given us notice or they given us notice, we would have corrected that. But it came out in the final order that this is what you haven't done. And we thought we had given under Rule 702, Rule 705, sufficient foundation, because the rules don't specify on an experience-based witness that there's any scientific test or any of that stuff that the judge was talking about. This is based on experience on the cases like Lagerquist, which I'm sure you're familiar with, and State versus Hutton, I think, is one of them, if not mistaken, and Hummert, and that deal with the ability of an expert who has experience, training, knowledge in the area, which clearly no one contested he didn't, to opine that it's probably more likely than not, under what he reviewed and under his experience over 50 years litigating, that a law firm like Greenberg Traurig would have more likely than not defended the claim. It's defense of the claim that's the key, because that's where the big damage was, the defense fees that accrued. We ultimately settled it, for very little, because the claim actually was very worthless. But it was the fees racked up by Mr. Sanis over time that caused a lot of the damage that we were seeking. And so why isn't Mr. Porter qualified? I mean, you can find 20 million reasons why anybody isn't qualified. But the question is he qualified under Rule 702 and 705? And what is in those rules or the cases under them to say that as an experience-based witness, he has no ability to be helpful to the trier of fact? As I said, even if he wasn't helpful, even if he didn't testify, there's certainly reasonable inference from the facts that we have that the firm would have, more likely than not, if that's the test, have defended the claim and not just sent him on his way and said sorry. And again, that's a factual determination. But we never got there. So bottom line is the other side never raised any of those issues, didn't present any controverting evidence saying otherwise, didn't produce anything from Greenberg Traurig saying, no, we would never do that. And we, unfortunately, are in a position where Greenberg candidly doesn't know what they would have done exactly because they're afraid to say so, because why should they? Going back 10 years. They don't need to say anything about it, okay? They don't know. And that's all we can do with it. And that's the best we could do with it. And as a result of which, we needed an expert to testify that basically, notwithstanding that no one can know today exactly what would have happened 10 years ago, that it's more likely than not, based on his experience, that they would have done so. I don't know why that's not admissible, or what else specifically the law requires him to have provided that satisfied the judge. And if it's just based upon a feel-good thing with the court to exclude testimony and throw out cases, I don't think that's a good policy. And there are certain witnesses, as you well know, under the rules that you have to establish certain foundation for scientific bases and things of that nature. With an experience-based witness, I don't see anything that I've reviewed, and maybe if you have, I'll be glad to hear it, or they haven't cited anything, that basically is compelling that this is what an experience-based witness has to satisfy the court of, other than the fact that he has that experience.
At this point, time is up. Mr.
Oh, I'm sorry.
Thank you.
Sorry about that. Time flies.
You must be having fun.
I must be having fun. Thank you.
Good afternoon. Charlie Callahan on behalf of the defendants Joel Sanis and Lakin Cobb, along with counsel Robert Burke. As I was listening to Mr. Wilczek, it just kept coming back to me. Where is the evidence that either Lloyd's or Greenberg Traurig would have paid for Mr. Aguilera's defense?
Well, Mr. Wilczek is arguing that obligation rested with your side of the aisle.
To produce the evidence?
That's what it sounded like to me.
Yeah, and that's what it sounded like to me as well, and I wholeheartedly disagree. The burden of proof on causation is on the plaintiff. And there was this discussion, there has been this discussion that we didn't satisfy our initial burden in our motion of pointing by specific reference to discovery in the evidence, to discovery, the absence of evidence on the issue of causation. And I think, with all due respect, I think that's just nonsense. In our motion, we cited specifically to the policy language that says there's a $7.5 million retention. Claims expenses are applied against the retention. Lloyd's does not have any obligation, or Lloyd's policy only applies in excess of the retention, including reasonable costs, fees, and expenses.
So, trying to understand what you're saying, it sounds like what you're saying is that under this policy, the practice would, an obligation would have been for Greenberg to incur the cost of defense and any indemnity and any settlement or verdict payment up to the $7.5 million, and that the reasonable value of that defense would count against the retention.
Correct. That's what, under condition 5D of the policy, it spells out the procedure. It says that when there's a defense of a claim, that the insured shall appoint an attorney, and Lloyd's gets to approve that attorney, and approval won't be unreasonably withheld. After Lloyd's approves that attorney, then the insured has to provide certain information if requested. It has to keep the Lloyd's updated as to the progress, and then once it gets to the retention, then that's when Lloyd's has the obligation.
Well, what about the situation where Greenberg isn't a named defendant, but rather one of its lawyers is, for conduct that occurred during that lawyer's employment? Whose obligation is it to pay that defense? pay for that defense up to the retention amount.
In my opinion, as I argued to the court, and it really hasn't been challenged, or to the trial court, and it really hasn't been challenged, is it's under the particular insured who's seeking coverage under that policy, who's seeking benefits under that policy, because the policy speaks in terms of the assured. And Lloyd's, in their typical fashion, uses assured instead of insured, but the assured is responsible for the retention. And as you know from a lot of cases here, Brown versus USF&G and American Family versus White, that when you talk about the insured as opposed to any insured, the insured refers to the person, the particular insured who is seeking benefits under the policy. So the person, the insured who is seeking benefits under the policy, has the obligation under the policy of the insured, assured, to satisfy the retention. Did I make sense?
No, I understand your argument. How's that? Mr. Wolinchek talked about the related litigation where Greenberg was named defendant, and it sounds like Greenberg and our Lloyd's undertook that defense.
Well,
and provided it to Aguilera as well.
Right, and I'm going to disagree with Mr. Wolinchek on a couple of points there. Before I do that, I wanted to kind of go back to, with respect to the Lloyd's policy that was in place in 2007, and whether Mr. Aguilera was responsible for paying the deductible. I think he was, to the extent he was seeking benefits or claims that we should have sought benefits for him under that policy. That policy says Lloyd's wouldn't defend you. Now, the separate issue is whether Greenberg Traurig, just as a matter of policy or whatever, would have paid for the defense regardless of any policy considerations. So I just want to make that clear. Now, to address your specific question with respect to the subsequent Yankee suit, Yankee occurred in 2009, and you look at Mr. Aguilera's affidavit. It's a very carefully worded affidavit. What he says is that a defense was tendered by Lloyd's. Okay, well, there's two different policies. In 2009, Aguilera had his own Lloyd's policy, which was a very different policy. It specifically said in there that there's a $10,000 deductible. First monies owed come out of that, for claim expenses come from that deductible. But that Lloyd's policy that was issued to Mr. Aguilera, different year, different syndicates issued it, and it had very different terms. It was actually, it says in there that the underwriters, the Lloyd's, has the right and obligation, or right and duty, I can't remember which one it says, the right and obligation to defend. That doesn't appear anywhere in the Greenberg Traurig policy with the $7.5 million retention. So Mr. Aguilera, after he paid and satisfied his $10,000 deductible, he was being defended by the Aguilera Lloyd's policy. Greenberg Traurig was named and was provided, or was being defended by an attorney. Mr. Wolinchek admitted, and the evidence is clear, there is no evidence as to who was paying that attorney, whether it was Greenberg Traurig itself or whether it was somebody else. And again, in 2009, it would have been under a different policy, so who knows what that Greenberg Traurig policy said in 2009 as far as defense and retentions and all that. There's no evidence of that. Did I address that question?
Yes.
But putting insurance aside, how do we know, because if I understand Mr. Wolinchek's argument correctly, one of the arguments is that, well, how do we know, or it doesn't have to be to a certainty, it only has to be more probably than not, or that Greenberg would have actually defended this claim. How do we know that? I mean, how can we say definitively they would not have defended the claim?
Yeah, and that's and I don't want to be misleading. That issue, I'm not arguing that I'm not arguing that we proved that Greenberg Traurig wouldn't defend. Our argument was, where is the evidence? Where is any evidence?
Your argument is you found a hole, a hole in their prima facie case, and it's their obligation to fill the hole.
Right.
And they haven't done that enough. But explain to me, why haven't they filled that in enough with the affidavit or whatever else they presented between the declaration and affidavit as to the possibility, at least? I mean, does it have to be more than a possibility that what's the standard? I guess that what bar are they trying to hit?
And I understand, Your Honor. Thank you. With respect to the Porter affidavit, I mean, frankly, I don't think that's an expert issue. You go to Greenberg-Traurig and you say, Greenberg-Traurig, would you have defended a former shareholder accused of fraud and accused of self-dealing? Would you have provided them with a defense? There's an answer, yes, no, or I don't know. Where's the expert testimony needed in that factual issue? And it is undisputed on this record that there was not a single witness or document disclosed from Greenberg-Traurig which would indicate in any way whether they would or would not have, or maybe not have defended their own shareholder, who's now their current shareholder again, would have defended their own shareholder. And that, there's no reference by Mr. Porter to any operating agreement, any shareholder agreement, any bylaws, any internal memorandum, any sticky note, nothing. There's no reference to anything in the record that Mr. Porter looked at or talked to address that issue. And sorry, Judge Campbell, you were about to.
Oh, I'm sorry. So you're not taking the position that Mr. Porter, at least in the abstract, he's qualified based on his experience and training to offer an opinion on the subject of legal malpractice and possibly what insurers might do under certain factual assumptions, right? But
as a standard of care expert, yes, I haven't deposed him, so I don't know what his qualifications are, but on standard of care, I don't dispute he's qualified.
But the basis of your argument relative to Mr. Porter's opinions is that there is not a sufficient factual basis for him to offer an admissible opinion.
Absolutely. And that was what Judge Corey hit on. And when
do you agree that that's an appropriate role for the trial court to make a preliminary determination as to whether there's a foundation for a proffered opinion?
Well, I not only think it's proper, but I think it's required under the Flores versus Sargent case. In Flores versus Sargent, the court held, I believe it was this court held, and the court is expected to exercise its discretion so as to prevent the admission of such opinions if there is any serious question concerning the admissibility under Rule 703 or otherwise of the underlying facts or data. The same, of course, is true on summary judgment.
So, another question, just Mr. Wolinchek raises this issue. I don't want to mischaracterize this argument, but it sounded like he was telling us that essentially they were blindsided by the judge's rejection of the affidavit on whatever basis, and were entitled to have some form of notice or the ability to have some sort of evidentiary hearing. What's your position on this?
Well, I disagree. I don't think they were blindsided, and I think that's not a failure on Judge Corey's part. This is a Rule 56 issue. Rule 56C5 states an affidavit used to support or oppose a motion must be 1, made on personal knowledge, 2, set out facts that would be admissible, and 3, show that the affiant is competent to testify on the matter stated. If you're going to submit an expert affidavit in order to avoid summary judgment, Rule 56C5 puts the onus squarely on the opposing party, the filing party, that if you're going to submit affidavits, they better be in order. They better be admissible. They better be properly supported. And for Judge Curry to come out and say you didn't comply with Rule 56, that can't be characterized as a surprise or a blindside. That's Judge Curry is doing his job. His gatekeeper function is directed by this court. That on summary judgment, Rule 56 requires appropriate facts and reliable facts and data before it's going to be considered.
And what was Mr. Porter's affidavit lacking under the rules? Personal knowledge, facts admissible, qualifications, which one was it? Or was it all?
The first two. The facts and reliable, personal knowledge and reliable facts or admissible facts. I mean, he offered two opinions. One was that Lloyd's would have defended. Based on what? He said that he reviewed the certificates of insurance. All the certificates of insurance showed was the amount of the retention. He had never said in his affidavit that he reviewed the policy. He didn't cite any terms to the policy. He didn't analyze any of the terms of the policy. He didn't discuss how insurance companies, when there is this kind of retention and when the language of the policy doesn't, or when the language of the policy doesn't require the insurance company to do anything until the retention is satisfied. He didn't offer any opinions or knowledge or evidence as to how insurance companies deal with that situation.
Let's talk about this affidavit in regard to Goldberg. What Mr. Lowencheck said, they're not going to say anything because they don't have to at this point. If they would, they wouldn't, or they don't know if they would have. So how is it deficient when it comes to, if we accept that 7.5 million retention is in play, and Mr. Willencheck says, well, Goldberg would have paid it because there's a shareholder here on the hook. Greenberg, not Goldberg. Thank you.
I was wondering who
Greenberg.
Goldberg
Sorry.
was.
I knew what you meant. I knew what you meant.
Thank you.
Well,
how is the affidavit deficient in regard to Greenberg?
because one, Mr. Porter didn't speak to anyone at Greenberg Traurig. He didn't review or cite any operating agreement, bylaws, policy manuals, anything. He didn't study how Greenberg has handled this in the past. He didn't ask anyone how it's been handled in the past. He didn't ask what, if you don't know, as has been represented by Mr. Willencheck, but which is nowhere in the record. Mind you, there's nowhere in the record that anyone talked to Greenberg Traurig and Greenberg Traurig said, we don't know how we would have handled it. That's nowhere. But assuming that somebody at Greenberg Traurig would have said that, well, then the follow-up response from Mr. Porter would be, okay, well, what factors do you consider in deciding whether or not to defend a former shareholder or a former attorney when Greenberg Traurig is not named as a party and is not potentially on the hook? What consideration does Greenberg Traurig give when the allegation against the former shareholder is that they aided and abetted fraud? What consideration does Greenberg Traurig give when the allegation is that the former shareholder had a deal through his separate entity that would get 5% of the profits from the sale of this property down in Mexico that wouldn't flow back to Greenberg Traurig? How would that affect your decision? And none of that is there. He said he reviewed dockets where Greenberg Traurig had been sued. That doesn't do anything. I mean, one, I've read a lot of Superior Court dockets in my life, and I'm sure it pales in comparison to the numbers you three have reviewed. And I've never once seen anything in there that says being defended by former employer or being defended by insurance company next to the defendant's name or anywhere in the listed motion. That it doesn't happen. And secondarily, he reviewed the dockets where Greenberg Traurig had been sued. Well, did he review any of the dockets where a former employee had been sued and not Greenberg, and asked Greenberg or studied contacted attorneys or witnesses or whoever and studied how Greenberg Traurig handled those situations when the former attorney was sued, but not the firm itself.
So if we were to disregard this expert's affidavit and rely on the other information presented, specifically Benjamin Aguilera's declaration and attached documents, how is that deficient?
Well, because the affidavit doesn't, Mr. Aguilera's affidavit doesn't really address what would have happened. It doesn't say that. Well, let me back up and split it into two: defense by Lloyd's and defense by Greenberg Traurig itself. All he says is that under his policy, which is completely separate, and they're both policies are in the record.
When you say his policy, is that the policy when you went to the other?
Right, the Aguilera International Council policy that was issued in, I think, 08 to 09. And that policy, completely different. When he said he was tendered a defense subject to his $10,000 deductible. I mean, all you can draw from that is he would have been tendered a defense subject to a $7.5 million retention under the Greenberg Traurig policy. Okay. And curiously, and I'll probably won't have time to end with this. Curiously, at the time when both he and Greenberg Traurig were sued, and he was not employed by Greenberg Traurig, and Greenberg Traurig was involved and was being defended, where is there anywhere in his affidavit any mention of a tender of defense to Greenberg Traurig at that time? I think that's curiously absent. That in a second suit, when he was being defended by somebody else and different attorneys involved, he had the opportunity to say, Greenberg Traurig, defend me, or suit here. There's nothing in there.
Thank you, counsel.
Thank you, Your Honor.
We thank you all for your arguments here today. We will take this matter under advisement and issue a written ruling in due course. At this point, we will take a brief recess to get the courtroom ready for our next argument.